competence and diligence, let's go into the last couple things with the time that we have left, and that is talk about being compassionate and actually caring about what you do. And this goes back to the principle of their lives are in your hands. There's probably nothing more scary than going into a jury trial as a defense attorney, knowing in your heart that your client is innocent, but there's evidence there that suggests that they're guilty, and you're the only thing keeping them from being locked away, maybe for a very, very long time. That's a heavy feeling, right? Or what's probably even, I say, scarier is the feeling of how many of us have kids, right? We love our kids. And a parent who's going to lose time with their child, or whether it's a divorce or custody, or social services coming and taking their child away from them, right? There's nothing more scary than thinking that you're maybe the only thing that keeps that person from having that relationship with their child. Now, there's good reasons. Social services attorneys here, there's good reasons why that would happen, okay? Greg's walking out of the room.
I'm going to snatch the babies.
Okay, go. So their lives, your client's life is in your hands. This goes back to the time management piece of things as well. And when we're talking about ethics and we're talking about doing the right thing, it's not all about winning. It is. I mean, your client hires you to win their case, right? But winning, can be defined in different ways. And I want to make sure we talk about that. As a defense attorney, you know that. A victory may be 1 year in jail instead of 10, right? So winning also may be this person goes away for the rest of their life, but they know that somebody cares about them, and that may be the first time in their lives that they've had somebody actually care about them. I've got a client who, a former client, who will frequently write me Christmas cards from prison. And he'll say things like, I hope your kids are doing well, I hope, some people might be freaked out by that. Know the guy, I got to know the guy. I went through 3 trials with him. Sarah, you know who I'm talking about. And he was, I don't know, we grew to know each other in a way that was more than just attorney-client privilege. It was a true friendship. I helped him through a very difficult part in his life, and he appreciates that. His life was in my hands, and I did the best I could with what I had to do. Right, Sarah? All right, let's move forward. Effective communication. In many ways, this is the beginning of all of it. In many ways, effective communication begins with this mutual respect. It's communication that inspires and encourages other individuals to do their best. Now, how many of y'all know that the rules of professional responsibility require us to communicate, right? Communicate effectively with our clients. Well, there's effective communication, and then there's effective communication. You know what I'm talking about? It's like, anybody remember Friends? The Friends episodes, right? The miniseries or whatever from the 90s. The other night when the presidential debate was going on, my wife looked at me and said, please, can we just watch reruns of Friends and pretend it's 1999 again? And we did. So Joey. Remember Joey, the guy that was able to get every girl just by saying, how you doing? Right? He had effective communication. All right. It's bad that I'm talking about Joey during the ethics presentation. Let's move forward while we can. How about Albert Einstein, who said, speak to everyone the same way, whether he's the garbage man or the president of the university. The next one. Be sincere, be brief, and be seated. Seth, yes, he was talking to me. Franklin Roosevelt. And then probably the best quote of all is this one from Teddy Roosevelt. That people don't care how much you know until they know how much you care. Now that can be demonstrated in different ways. Your zeal in representing someone, a client, your taking their phone call and communicating with them, or in court when you're in front of the judge putting on that show for your client, right? And I think there's probably all are acceptable under the rules, but there's some that are better than others. When you look at getting the most for your client, right? And that's the title of this presentation. Yes, winning is a priority. Your client hires you to do that. But it goes past that to actually showing them that you're doing everything you can for your client. And that truly, if you look at this, quote, until they know that you actually care about their cause, they don't care how smart you are or how high paid you are or what they want to know that you got their back no matter what happens in that courtroom. And that way they're not whispering in your ear the whole time, object to that, object to that, object to that. They trust you to do what's right because you've developed that relationship with them in a positive way. Rule 1.4 talks about communication. A lawyer shall keep a client reasonably informed, right, about the status of the matter and then promptly comply with reasonable requests for information. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions. Oh, spill coffee. We're okay. It'll dry. And a lawyer shall inform the client of the facts pertinent to the matter and of communications from another party to another significantly affecting settlement or resolution of the matter. Now, let's talk about that in terms of what you actually really have to do. You know, communication, clients are not entitled to micromanage the case, obviously. And lawyers are not expected to confirm every single little move with their client. But when anything important happens in the case, the lawyer has the duty to communicate. This goes back to the principle of what kind of lawyer would you want if you needed one. Of course, you're going to want to be kept informed of the things that really matter. You're not going to want to have to worry or stress out over every little tiny micromanage the case, every little tiny detail, unless you're OCD like me. So the client alone has the right, though, to make those major decisions. This is what the rules tell us, right? The client can make those major decisions, like whether to settle the case or whether to plead guilty in a criminal trial. Obviously, that you as a lawyer should be the one who's advising the client and telling them what your legal professional opinion is in this matter. Again, going back to effective communication, it is what a person can trust you to do. You can advise them, you know, I really think the evidence is stacked against you and you ought to plead guilty or whatever it may be. But unless they trust you, they're like, I'll go get another opinion or another opinion or another opinion. Rules do require you to actually have effective communication. Now, what if the client believes that is, what if the lawyer believes the client's decisions are foolish or immoral? I tried to make this come in with the answers later, but this is part of those slides that freaked out this morning and messed up. So the client has, I'll tell you, the client has the legal authority to make those decisions. Even if you think this is a wrong decision, it's the client's decision. Is the lawyer still entitled to try to talk them out of it? Well, lawyers are required to be candid with their clients and to exercise independent judgment, right? But the rule specifically requires it permits the lawyer to go beyond purely legal considerations in a conversation with the client and moves forward to refer to moral, ethical, social, and political factors that also may be relevant to your client. So the rules actually require you to go beyond just telling them what to do and not, but to actually have a true meaningful relationship with your client in a way that they trust you and believe you. There it it goes. See, there's the graphic I tried to make it do this morning. Keep going. All right, let's talk about this. Mail. You've got mail. All right, so I just, curious show of hands, how many of you all send letters to your clients frequently? Huck, yeah, Donnie. I used to all the time. Initially, when I got a court-appointed case or whatever, I would send a letter to my client at the last known address. Every time I met with them, I'd send them a letter confirming we had this meeting, that kind of thing. I was careful not to put too much confidentiality in a letter just in case it got intercepted, but to make sure that they knew that I was communicating with them. And I didn't get paid for all the letters I sent out. I didn't expense that. That was just part of what I felt I needed to do, not only to document what I was doing for my records, but also to let them know that I was working on their behalf and I cared enough about them to send them letters. And I actually had a client once say, wow, nobody ever sends letters anymore. And that was a big deal to that guy. So whether you send letters, or maybe you do things by email, or maybe you just use the old-fashioned phone, or maybe you make house calls, I don't know. Communication is key. Comment 7 to Rule 1.4. In some circumstances, a lawyer may be justified in delaying transmission of information when the client would be likely to react imprudently to immediate communication. Now this is tough, right? Thus, a lawyer might withhold psychiatric diagnosis of a client when examining a psychiatrist in the case that they would do harm to themselves or something of that nature. A lawyer may not withhold information to serve the lawyer's own interest, however. Obviously, that is unethical. But you do have some discretion to delay communication if you think it would be harmful to the client. Then obviously, the other part of actually showing you care is advice. Communication is not just relaying information of you better show up at this court date. It's also advice for your client. You've got, it's attorney and counselor. You're supposed to actually advise your client on life. I mean, you can't just leave things in black and white. You need to advise your client on what's right and what they should do in this particular circumstance. In representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering that advice, a lawyer may refer not only to the law, but all these other factors as well that we're talking about. And then the comment rule comment 1 to the rule is that the client is entitled to straightforward advice, expressing the lawyer's honest assessment. How many of y'all know that straightforward advice is sometimes hard to give, especially to somebody who doesn't want to hear it, right? And that is an art form in a sense. I mean, you really have to work very hard to make sure that you communicate straightforward in a way to your client, something that they don't always want to hear. The way I always would do it in criminal, or well, in any way, and I do it even now. If individuals don't want to hear, I show the evidence. I showed what it was in front of me that shows why I need to do this and why it's in their best interest to do that. And the communication between the two, if you develop a relationship, maybe they might react in a positive way to that. Then again, they might fire you and go hire somebody else. But that's okay. You've done what is ethical and what you should, and that's try to make sure that you communicate those. And you have to communicate in a straightforward way. Like this, right? We got counseling help, right? The doctor's in. We're not doctors, but we do provide counseling services to our clients. Hey, let me pause here and tell you this. Y'all know where Snack Shack is? My kids love Snack Shack. Snack Shack down in Orton, right? My kids love Snack Shack. And Colin, my 4-year-old, actually likes salad. I don't know, he's a 4-year-old that likes salad. Believe it, I am a lawyer telling you, but yes, he loves salad. And so, one day, Erin, my wife, took him to Snack Shack at lunchtime, and they were there getting ready to go in. She gets out of the car, sets him here, or stands him by the car. She had to go around to the other side to get her purse and said, little buddy, touch the car, don't move. She comes back, and he's gone. You know, that freak out moment, right? Oh God, where is he? And she looks, scans the parking lot. I mean, it's not a very big parking lot between here and the door, but scans and then sees him and is horrified. His pants are down around his knees, and he's sitting there peeing on the flower. That's my little buddy. And of course, there was a group of little old ladies who were standing there watching him and cackling out loud and laughing at it. And no, little buddy. That's what we're talking about. You know how innocent and sweet that is. Of course, kids need counseling. They need the advice of what to do and what not to do. In a lot of ways, clients are the same way. If you don't make sure you communicate to them effectively, the next thing you know, they might be having their pants down, peeing in the corner. You never know. So you have to make sure. Rachel's mouth is wide open. I must have said something I shouldn't have. And so that's part of it. Okay. And we've gone over this stuff almost. Again, I made the same point 20 times in a row. Yeah, I made that point again too. Okay, how about this one? Comment 5 is interesting to Rule 2.1. In general, a lawyer is not expected to give advice until asked by the client. However, when the lawyer knows the client proposes a course of action that is likely to result in substantial adverse legal, moral, or ethical consequences to the client or to others, duty to the client under Rule 1.4 may require that the lawyer act and go ahead and advise them of that if they've not asked for the advice. So again, it's like your client, you need to make sure if it's likely and the factors, you foresee he's going to go pee on the plant in the corner, you need to make sure you advise them ahead of time, even though they've not asked for advice on whether they should pee in the corner. What about clients with impairment? How many of y'all do guardian ad litem work, represent kids, or incapacitated adults? Now, this is something that you've got a client with an impairment. When a client's capacity to make adequately considered decisions in connection with representation is diminished, whether because of minority, mental impairment, or some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client relationship with that person. But when the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonable necessary protective action, including consulting with individuals or entities that have the ability to take that action. Those cases are in particular, you've got to communicate in a way, but then a lot of times you're communicating with your client and then acting in a way to preserve their client's best interest, but they might not necessarily like or want, right? Those are tough cases, especially if you're representing kids. To try to explain to a child why you recommended that they go live with mom when the kid wants to go live with dad. That's heavy. Again, those decisions and that type of communication, you have to have that relationship with your client in a way. That's why a lot of times when I was doing guardian ad litem work, I would try to see a client, a child, several times before having a deep conversation, or at least before court. Before I was making a recommendation about that child's future, I wanted to get to know that child and their life. So I would go to school, meet them in a neutral place, and just have a conversation. I would try to meet them at both parents' homes so as to see that I'm not picking one side or the other, and develop a rapport with the child so that the child wouldn't think that I'm trying to tell that kid what to do or what not to do. That's a difficult thing to do. It's especially difficult if you're busy and you've not prioritized well and you are trying to do 12 things at the same time. Kids hate when you're talking to them and you pull your phone out and you have to check an email and then you keep talking. I'm guilty of doing that at least once, and I know that disrupts rapport. Again, the ethical rules say nothing about getting your phone out and looking at it while you're talking to a client, but the ethical rules do say that you're supposed to have effective communication with your clients. And thus, if you're talking with your client, you pull your phone out and look at it, and keep talking with them, pull your phone out and look at it, you may not be able to effectively communicate with your client, and I would argue you may be acting unethically in that moment. Let's keep moving. We're almost done. We got another 10 minutes or so, and then I'm going to break. How about that? Let's keep moving past it. The comments here are all in your materials. You can read those if you want to look through the impairment section and the communication section. All right, so then being an advocate. And again, we go back to our initial discussion of what does it mean to get the most for your client. To win, to advise your client, to develop a relationship with them, that they trust you. One of those things is to be their advocate. And being their advocate is begun by having integrity. Now, John Maxwell, again, I'm going back to refer to John Maxwell, says integrity is what we do so much as not what we do as much as who we are. Now, we're lawyers, and we go back to our beginning discussion. We became lawyers to do something. For the most of us, it's to make a difference in other people's lives. So, when we're advocating for our client, we're expected to have that integrity. And it's not as much that you're just a lawyer, but you are a lawyer for that person. You're an advocate for that person. And who we are in turn determines what we do. So when we begin, we need to begin with the end in mind. What I mean by that is when you're dead and gone, somebody's going to say something about how you lived your life and how you represented clients and what you did in your profession. Each day when you wake up, you need to begin with the end in mind. And think about it in terms of, what are they going to say about me when I'm gone? Now, you may not care what they say about you when you're gone. But ultimately, if you're trying to do the right thing every time, each morning when you get up, I always say a little prayer for my client, or for what I'm doing. God, help me to do what's right today in all circumstances and situations. Whatever your faith may be, maybe you might say, I'm going to get up and I'm going to do the right thing and advocate for my client every day, beginning with the end in mind. Or you can do this. First, we deny any wrongdoing, and then we play up any right doing. So integrity takes multiple forms, and I wonder if all of us would be able to do this. Here's a Georgia guy. Georgia executed this Alan Cook guy. Do y'all know, is anybody familiar with this story, this Alan Cook story? So there were two students that were killed, college students that were killed. And the FBI was involved, investigating and trying to figure out what was happening. Well, one of their suspects was this guy, this Cook guy. And his father just so happened to be an FBI agent. So his father calls him up and says, Alan, if you know anything, you need to come clean. You need to tell. I'm telling you, you need to come clean to tell. Did you shoot him? And he confesses to his father and says, yeah, I shot him. Well, fast forward, Alan's dad, as a cop, had the responsibility to tell somebody. So he told the other officers, my son confessed to me. So then the legal question became, was that communication a privileged communication between the two of them? Such that, at father-son communication, and it would be inadmissible? Or was it an investigator, a cop, talking to a suspect? And guess who's the only person that could actually say how they were acting? The only person was the FBI agent. It was Dad. And Dad had to say, knowing that if he said it was father-son, he might save his son from the electric chair. Or he said, I was acting as a cop, then his son's going to be convicted and executed. And of course, said, no, I was acting as a cop at the time, interviewing the suspect. That's tough to do the right thing. That's integrity, right? Putting self behind you to do what's right. I don't know that I can do that. But that's what we should strive for, right? To do what's right in all circumstances. Here's the actual story about it. When you all get the slides, you can go through and read this particular case or look it up. Obviously, some of the last things we're going to talk about, you're an advocate and you want to win, but you need to do it in a way that's honest and fair. Again, there are lawyer jokes for a reason. We're an easy target, but we want to try not to be the butt of one of those jokes. And the rules make provision. Again, this is one of those do nots. Do not make up evidence or do something malicious. No meritorious claims and contentions. A lawyer shall not bring or defend proceeding or assert or controvert an issue therein unless there is a basis for doing so that's not frivolous. Which includes good faith argument for an extension, modification, or reversal of existing law. A lawyer, y'all get it. You're supposed to go into court and be honest up front. Candor to the tribunal is another one of these rules, and we're going to talk about it in a second. There is a legal ethics opinion out in Virginia. Of course, this shouldn't surprise any of us. We'll read if the threatened legal action is without legal basis in fact or law, and the threatened suit is made merely to harass and intimidate a witness or influence the witness not to come forward with truthful and relevant information, then the attorney or the plaintiff would be in violation of the cited rules and opinions. On the other hand, if the lawyer for the plaintiff has a well-founded belief that the threatened legal action is warranted based on contentions of the complainant letter, said the Homeowners Association. All right, I don't know all the facts of it, but essentially, y'all get this. It's not a good thing for you to make up some claim to try to gain an advantage. We all work together. We all trust each other. We hope that we can believe each other's word when we say something. And that goes beyond just doing what's ethical. It's doing what's right for your client. Okay? All right, the last thing. Be truthful and loyal. We're going to skim through this because y'all already know this part. And that is you need to have a certain integrity about you. Again, you have, as we began with, you're a principal, or you're a agent of the principal, so there's a fiduciary duty involved in your legal representation. And it turns out that fiduciary means that you have to give it back, according to this. Or you have to do what's right for your client. And we know what fiduciary is. The law creates this special relationship with folks where a special position of trust with respect to clients with heightened obligation of loyalty and integrity. And as a lawyer, you're held to something stricter than just morals in the marketplace, not honesty alone, but the punctilio of honor, and the most sensitive is the standard of behavior. So you need to be truthful at all times with your client, with others. Making false statements are unethical. It's also wrong. It's not the right thing to do every time. Incorrect answers on an interrogatory, according to this legal ethics opinion, also is false, and misrepresentations of the availability of witnesses, it's improper. Y'all get it. Y'all know this. It's about time for lunch. Y'all get that. You know that too. And then, of course, candor to the tribunal. You all need to always be truthful. And in a way, being truthful is being loyal to your client. Obviously, your client wants a lawyer to be able to advocate for them, and if they say something, the court and everyone else knows that it's solid as a rock and not squishy. And that's not a legal term of art. Let's keep moving. Here are some comments for the rules. I think we're almost done. Go ahead, one more. Keep on going. Okay. Of course, if you're 58 years old, your lawyer can't change it to 32. I meant to tell my joke there about the 99-year-old lawyer, but I told it earlier. I got excited. Of course, you need to be loyal. Be loyal to your client. Be loyal to your humanity and the profession that you've chosen to be. And that's keep confidential those things that are confidential. That's Rule 1.6. Conflicts of interest. Don't have a conflict and try to represent two people at the same time. You know you shouldn't. And then dealing with people who are unrepresented carries a certain specific ethical standard that's well under Rule 4.3. All right. Let me end with this. And that is, we've gone round and round. We talked a whole lot for 2 hours about ethics. And I can't believe we've actually done it. 2 hours of ethics. And I've tried to keep you up and moving and entertained enough to be able to not fall asleep and risk your law license for it. So I appreciate your attention. I appreciate what you all do. It's not that y'all aren't just colleagues. Y'all are my friends. And I'm thrilled that, I mean, I look around the room, I see so many of you that I have worked with for many years, and I see some who have been role models and mentors in a lot of ways of me. And I think, what are we doing moving forward as a profession to try to make our community better? And each and every day when you come to work, when you're representing clients, when you're trying to do what's right, you're not only a representative of your clients and hopefully your good name and your future, but you're also a representative of our community and what we're trying to do to make it better. We all love this region. We all love the people. And there's a reason why you became a lawyer. Each day when you get up to go to work, it's not just work for most of us. It's our passion. It's our life. Don't ever lose sight of that. And don't ever have that moment in which you have to even wonder, what do the rules say? If you're doing what's right every day, you're not going to even have to worry, because you'll know in your heart. All right, thank you all so much. Appreciate you.